The jury will not be sequestered.
I'm Brian Buckmeyer along with Terry Austin.
In the Weinstein case, fellow silence breakers and any...
Jury selection is moving along
Well,
here.
I'll read the verdict, says the Jesse Weber. Thanks for joining
We
us.
don't tend to see it as raw as this.
Good evening and welcome.
Welcome to Law and Crime Networks. For the record, my name is Bob Bianchi. Be taking it to 3 o'clock. Got a lot on the plate. As you know, the Kyle Rittenhouse case, they were on day 3 of verdict watch in that case. And of course, if any developments happen in court or a verdict comes out, we will be covering that gavel to gavel, as you know. And we are also moving into this case of the shooting death of Ahmaud Arbery, to Travis McMichael and William McMichael, as well as William Rodney Bryan, are on trial for a potential life sentence for malice murder with respect to that case. And the most perhaps important witness in the case, because we are on the defense side of the case, testified, Travis McMichael, the shooter in the case. Obviously, very compelling testimony that is going to make a crucial difference in the jurors' minds as to whether or not he had acted reasonably when he used lethal force in the killing of Ahmaud Arbery. Let's take a listen to a little bit of his direct examination.
You see in the video, we all see in the video where you raise your shotgun.
Yes.
You see that?
Yes.
Okay. You remember doing that?
I do.
Why'd you do that?
He was closing in. At this point, I've yelled at him to stop several times. This one again, I've screamed at him, stop, screamed, stop. He is focused in on me, and he's at this gate where he's looking like he's about to run. He has the possibility to get this burst out. And if he gets this burst out at this point when I pulled the shotgun, I wouldn't have time to react if he wanted to get on me or to pull a gun or have a knife, or if he wanted to do ill will. At this point, this is when I needed to show him to deter him to do not come at me.
How do you know at this point you have to do that?
Because everything that's happened, everything that's going on, and him closing in on me.
No, I mean, how do you know at this point that you have to raise the gun, or he could be on you like that?
From training and prior experience. There's a thing called Tooler drill.
A what?
Tooler drill.
Okay.
A 21-foot roll, I think, is popular.
Okay.
It says that any average person, it takes 21 feet for somebody to react. It's an average of 21 feet for somebody to react, to pull a weapon and fire 2 shots at somebody that charges you with a knife or anything like that. Mr. Arbery's already running. He's at a pretty good clip. He's directed at me. He sees that I have a weapon. I'm yelling at him to stop, and he's continuing. At that point,
he sees that you have a weapon.
Mm-hmm.
How do you know that he sees you have a weapon? What do you do?
I had the weapon out at this point, and I had it down at a position like this. Port arms is what they call it. Okay. And it's blatant that I had this shotgun.
On you doing what?
He grabs the shotgun, and I believe I was struck on that first instance that we made contact.
What were you thinking at that moment?
I was thinking of my son.
What did you do?
I shot.
All right, we have Casey here early with us, criminal defense attorney. Casey, welcome to the show. What did you think about the testimony of the defendant? And there's been some controversy, of course. Everybody's a Monday morning quarterback as to whether or not the defendant had to testify in this case. What are your thoughts?
I believe that the direct testimony was rehearsed and scripted. He was using some terminology that typically only attorneys would utilize in closing arguments. Although it was compelling, I do not believe it was credible. And some of his rendition of what occurred that day, it came out on cross-examination that he could have utilized alternate ways to, quote, apprehend this guy who he thought was burglarizing the homes, and he chose to utilize this force. So I do not think it was credible. And who knows, maybe it came across that way to the jury, but not to me.
Yeah, interestingly, he got a lot out, though, in a personal way. He's a very trained person with regard to quote unquote de-escalation techniques, which has made me laugh because I tried to put this together in my mind. If you look at this and you look at the Rittenhouse case, it's kind of the same thing. You carry a gun for protection. An incident happens. This is part two. You pull the gun out to protect yourself from that incident. The person on the other end of that weapon is now in fear that they're going to get shot because a stranger is pointing a gun at them. They go, perhaps, these could be the facts juries find out, to grab the gun in order to protect themselves. And because they grab the gun, the person who has the gun says, well, once they get my gun, they could kill me, and they shoot. There's an irony in all of this, is there not?
Absolutely. And here's the thing, when you have this AR-15 rifle or whatever, assault rifle or gun period, you expect as a person with this weapon to be in control, right? You expect to be respected. And in this instance, he was basically recalling the facts that I had my gun, it was visible, and he didn't follow my commands. And in fact, he came to me, he overpowered me, and I had no other choice but to shoot him. That's essentially what his story is. And similar with Kyle Rittenhouse, he had this gun, and typically people respect authority, whether it's your position or your power. In this case, that gun was a sense of power. But I don't buy that story, because there were alternate ways for him to subdue Mr. Arbery if he believed that he was in the process of committing a crime, had committed a crime, but he chose to utilize this weapon. And unfortunately, this happened. I mean, it's a murder, clear as day. And I do believe that the jury will see that it shouldn't have happened that way, unfortunately.
Well, an interesting fact about this case is that he also testified, and I think he had to testify. When you're asserting a self-defense claim, I think you need to get up there to explain to the jurors what was in your mind. But 12 days earlier, the defendant claimed that there was an encounter between him and Mr. Arbery at that same property that we've been talking about, which at a certain point in time during the shooting incident, he recognized him as being the same person. Let's take a listen to that.
So he's 20 or 30 feet behind the portalet coming from that house. Again, obviously, he's aware that I am aware that he's there, had lights on him. I get out of the vehicle, it's a standard car, so I put it in parking brake on, step out of the vehicle, and was going to ask him what he's doing.
Sorry, what do you mean by standard car?
It's a stick shift.
Okay,
stick
go ahead.
Shift. I get out of the vehicle, he's trotting to me.
All right, stop. Why are you getting out of the vehicle?
To see what he's doing, to ask him what he's doing, maybe run him off.
Okay.
I haven't seen before.
Okay.
At all.
Did he wave at you?
No, he didn't.
Did he try to talk to you?
No, he didn't.
Like,
that's
I
why I
lost
was
my
thinking,
dog or anything like that?
Mm-mm.
Okay, so what happened? You step out?
I step out to ask him, to see what's going on, to get an idea what's happening. As he comes out of the shadows from behind that portalet, he comes directly to me. I'm out of the door, and he comes out and he pulls up his shirt and goes to reach in his pocket or waistband area, going for his pocket. I thought it was pocket at first, but later on it didn't make sense, because if you're going to reach for your pocket, you would go for the pocket that's on whichever side you're on.
Okay.
He reaches like this.
So what happened at that moment?
It freaked me out. So once I realized what's going on, that he is doing this, and I'm under assumption that he's armed, I jump back in the vehicle. He turns around and runs into the house.
Okay.
Into the 220, the house at 220.
All right. So from the porta potty,
Mm-hmm.
coming forward, then he goes into the house.
Yeah, he stopped. And once I jump back into my vehicle, he just turns and goes into the house.
All right.
Runs. It wasn't like a full sprint. It was, he's gone. Let me continue what I'm doing.
Okay.
What
did you do at that moment?
Well, it startled me. It freaked me out. So I don't know if I had my phone in the vehicle or not. It wasn't there. I didn't have a gun on me. He's gone. I'm just getting the hell out of there. I just wanted to leave, make sure, because I don't know where he's at this point. I go to jump in the car and take off to the house. I forget that the parking brake's on. I stall the vehicle out, crank the car back up, and get to turn and go back to my home. So once I get home, I believe my dad was in the garage, or the garage door was open.
Okay.
Or may have been in the kitchen. I told him what just happened. And I had two phones, had my regular phone and my work phone. And best I could remember what I was doing was going to grab a phone. Well, I told Dad, I said, hey, there's somebody, I just caught somebody lurking at the neighbor house and just went into 220. So he comes out and I'm assuming his arm and goes down the road.
Okay, hold on. Let me stop you there. When did you call the police?
I did.
All right.
Yeah.
Where are you when your dad starts to walk down the street?
I was at my vehicle. I was at the driveway.
Okay. Did you say anything to your dad?
Yeah, I told him to wait. I said,
Why?
hold on a second. I don't know what's happening. I'm assuming this guy's armed. And Dad, he had a stroke a couple months earlier, 2-3 months earlier, and which everything's fine, but you're concerned about him. If somebody,
Does he have any other health issues?
Yeah, he's got a busted hip, or he's actually had a total hip replacement, and he's had a couple heart attacks. And
okay. So you say, Dad, wait.
Yeah, wait, and he's walking on down the road. He's going on down the road.
All right, what do you do?
So I go in, grab the keys to my truck, and grab one of my guns, which was at the safe, which was in the garage right there. Get out, get down to the road where Dad is. I'm calling 911 at the time. By the time the operator picks up, I pull up to 220. And at that time, my father and I wasn't aware who it was at the time. Another neighbor, Dad was interacting with. I didn't know who it was. It ended up being Diego Perez.
What kind of truck are you in?
A red Ford F-150.
Okay. Are you okay?
Yeah. It just startled me. When I turned around and saw him and backed up, he reached into his pocket and ran into the house. So I don't know if he's armed or not, but he looked like he was acting like he was. So, be mindful of that.
Okay. Which pocket did he reach into?
Left, I believe.
So be mindful of that. Again, may be obvious, but what is it that you're trying to communicate?
That the person that I just had this interaction with, possibility is armed and is obviously willing to use it if that was the case.
Well, why are you telling the 911 call center operator to be mindful of that?
So the police that show up on scene would come in knowing what they're possibly walking into.
Okay. And now, so 230 is the vacant lot address?
It's my address.
It's your address?
It's probably
okay.
228 or 226.
Maybe 226?
Possibly.
And how many houses down is it from yours?
It's 2 towards the highway.
KC, I think sometimes when we analyze these cases, you sit where you stand. You could go with a gun in New Jersey and you pull it out. We have some of the strictest gun laws in this country. You know there's a problem. But this isn't New Jersey or New York. This is Georgia. That carrying weapons is a common, ordinary thing, just like it is in Kenosha, Wisconsin, on Rittenhouse. So I want to go to this call. This incident, you could tell he's exasperated. He sounds out of breath. He talks about the fact that he thinks he may have a weapon. And this is just 11 days before supposedly the defense says he re-encounters Ahmaud Arbery, recognizes he's the same person. Obviously, the defense is trying to show here he would have a heightened sense of danger because of the previous encounter. He thought he had a weapon. It's a fair point for the defense to make in terms of what his state of mind was on the day of the shooting, no?
It's a fair point, but I go back to credibility. I dissected that 911 call versus his testimony that he testified on direct examination. He stated in that 911 call that he reached into his pocket. He never said waistband. So a reasonable person would assume that a person typically carries a gun in your waistband. You don't carry a gun in your pocket. So if there wasn't a gun in his pocket, there could have possibly been a knife, which can be considered a weapon. Here's why that's important for the prosecutors. And if they didn't bring that out, then they definitely have to bring that out in closing arguments, because he brought a knife to a gunfight. The defendant brought a gun to a knife fight, because if he believed that Ahmaud Arbery had this weapon, then he created this danger, and now he's in fear of the danger that he created. again, and then he tried to change his testimony on direct examination that he reached crossover into his waistband as opposed to his pocket. I don't believe it. Typically, what the truth is usually what your first statement is because it's closer to time. So again, his whole defense is built on assumptions. He assumed this guy was burglarizing a home. He assumed that he was dangerous, and he assumed that he was in a place where he was not supposed to be. So again, if I'm the jury, I'm comparing his 911 calls to his testimony on direct examination and cross-examination. And if he is not credible and consistent, then his whole story it goes away.
Yeah, it'll be interesting. We always say it goes down to the jury charges, just like in Rittenhouse too. It depends on what the judge instructs on the law, because a belief can be mistaken, but still reasonable at the time of the incident. So we'll have to see if the judge is going to charge that, to your point. Anyway, guys, we're going to take a quick break here at the Law and Crime Network, but don't go anywhere. We have Angenette Levy in Kenosha, Wisconsin, on the Rittenhouse case to give us some updates, and we'll talk about that on the other end. Please stay with us. All right, Kyle Rittenhouse, we are on verdict watch, day 3 of that case that will decide his fate as to whatever this jury does with respect to its verdict. We have our very own Angenette Levy that's out there in Kenosha, Wisconsin. And I heard just before we went on, I'm cold, and I can see she's got her hat on, and now her jacket zipped all the way to the top of the neck. Angenette, welcome to the show. And I hear there's been some pretty extraordinary developments that are going on out there. Tell me about them.
Yeah, thanks, Bob. You know, it's this is actually very disturbing. We are here at the Kenosha County Courthouse. We've been here since early this morning. The jury deliberations resumed around 9 Central Time. We were in the courtroom, all just sitting there. The judge was doing his regular docket. We sit in there because we don't want to miss anything, right? So we're sitting there, and the judge says to someone, "Find MSNBC." So we're thinking, oh gosh, did somebody do something wrong? It turns out somebody was apparently following a juror or jurors, and this person was approached yesterday by Kenosha police. It sounds like an arrest was made. The people with MSNBC and NBC were apparently, according to another reporter's tweet that I saw, shown a photograph and said that person does not work for us. So this matter is still under investigation, and this all unfolded yesterday. So during a break in one of those other cases on the judge's docket, one of the reporters in the courtroom asked the judge, hey, what's going on with this? Can you tell us anything? And he said, I'm going to make a statement about that this morning. And, you know, we kind of asked, well, has this affected deliberations? And he said, I'm going to wait, and I'm going to make a statement about that this morning. So it sounds like a person has been arrested. This remains under investigation. We really have kind of sketchy information about this at this point, but that's what we can tell you about that. And, you know, I've been covering the courts for a long time, Bob. I know that you're an officer of the court, and you've been doing this for a really long time, too. So that's just kind of, you know, if somebody was following the jurors or a juror, that's unacceptable.
Yeah, Angenette, I'm glad we can get into this topic, as disturbing as it is. I personally think the judge should have sequestered these jurors from the very beginning. Okay, that did not happen. I'm sorry, Angenette, I'm going to have to cut you off. I'm being told by the producers that the judge is on the bench. Maybe we'll be back with you. Let's go live to court.
Good, thank you. Thank you.
Okay, you're not hearing any audio right now because audio is not on. The judge is not speaking, but the attorneys, as you can see in Kyle Rittenhouse in your monitor, is in the courtroom, undoubtedly going to be speaking about this issue about a potential jury tampering issue. This is a big deal amongst many of the issues that have occurred in this trial, including motions for a mistrial that are pending Now we have this, and this could potentially taint not only that juror, but all of the jurors. It has always been brought into question in my mind as to why the jurors were allowed to have such interaction with the public. And I was going to ask Angenette, maybe we will on the other end, whether or not anything was done to stop the jurors from listening to the protest. I don't care whether it's on one side or the other side. Angenette, how about that until the judge starts speaking? Was there anything done to keep the jurors away from listening to these protests, to these demonstrations, and these jurors? Apparently not.
Not that we know of. Yesterday, it seemed a little more quiet yesterday. There have been people with bullhorns, people playing music. And when I was out here yesterday, I went up to one of the gentlemen on the courthouse steps who was using a megaphone. I had overheard him say that someone told him that his megaphone was upsetting the jurors, or they could hear it, or it was scaring them. So I asked him about that, and he and his friend said that's just something that's been said to them among the crowd. So it seemed like yesterday the bullhorns and stuff like that weren't as loud. But, and they haven't been quite as loud today either. They were louder the other day. So I don't know if they've toned it down a little bit. Because you shouldn't be scaring the jurors. There's a long history of that type of thing, down in the South, people gathering outside of courthouses and screaming and yelling to intimidate juries. And that's just something that shouldn't happen. So I don't know. It didn't sound like they were formally asked to quiet down, but you can hear them chanting behind me right now, probably. I mean, I don't know if the jurors could actually hear that. But as far as the bullhorns and all that stuff goes, that seems to be a little much, and it hasn't been as loud as it was on Tuesday.
Angenette, I've been involved in high-profile cases where there have been demonstrators and things like this, but we all have a First Amendment right. We get it. The right of freedom of assembly, we get it. But every judge I've been involved with has shut down any possibility that jurors could be influenced in any way whatsoever, because their constitutional rights end where the defendant's constitutional rights begin. So it is really upsetting, if I'm hearing you correctly, that jurors are afraid because they're hearing all of these demonstrations, because we want them to be dealing with the facts of the law and not what the court of public opinion thinks. I mean, how did jurors possibly handle that situation? I'm being told, Angenette, we are going live in the court. Judge is speaking.
Rittenhouse, and the media have been asking questions. There's been conversation around this morning. We had asked the media coordinator to determine possible whereabouts of certain persons because we received a report this morning from the Kenosha Police Department that last evening, and let me just set this background here. The jury in this case is being transported from a different location in a bus with the windows covered so that they don't have to look at aren't exposed to any signs by one side or another or interest in the case. And so I'm going to call it a sealed bus. And that's been done every day, and then they're brought here to this building. And last evening, a person who identified himself as James G. Morrison and who claimed that he was a producer with NBC News, employed for MSNBC, and under the supervision of a person, what's going on? Oh, okay. Under the supervision of someone named Irene Bion in New York for MSNBC. The police, when they stopped him because he was following at a distance of about a block and went through a red light, pulled him over and inquired of him what was going on, and he gave that information and stated that he had been instructed by Ms. Bion in New York to follow the jury bus. The matter is under further investigation at this point, and the media has asked questions about it. That's the latest I have. And he was ticketed for violating a traffic control signal. He's not here today from what I'm told, and I have instructed that no one from MSNBC News will be permitted in this building for the duration of this trial. This is a very serious matter, and I don't know what the ultimate truth of it is, but absolutely it would go without much thinking that someone who is following the jury bus, that is a it's extremely serious matter, and will be referred to the proper authorities for further action. Thank you.
But Angenette, from what I can understand from what the judge said, there was an arrest of somebody from MSNBC that was following a jury box. So judge indicating it's a very serious matter and it's going to be referred to the authorities. What do you make of any of this?
Yeah, it's interesting to me because I'm a little bit confused, and we're going to have to try to get some more information about this. He said they were ticketed for not obeying a traffic signal or something like that. So we don't know if there's been an official arrest made, but this person named James J. Morrison told Kenosha police, according to the judge, that somebody in New York, and I don't remember the woman's name, but that she told him to follow the jury bus. So he says it's under investigation. It doesn't sound like this person has been charged with any type of jury intimidation or tampering or anything like that. But obviously it's a very serious matter. He says the bus is blacked out, so the jurors aren't seeing anything. And I would assume that's so people can't see in either. And so this is incredibly serious. And I think it's interesting, though, we were hearing, at least one of the other reporters here for the Milwaukee Journal Sentinel was reporting on Twitter that the people with MSNBC and NBC said that that person didn't work for them. But now the judge is saying nobody from MSNBC can be in the building for the remainder of the trial. So that's a pretty big deal.
Yeah, okay. Angenette Levy, thank you for the great reporting and the breaking news. We'll be back in touch with you later, Angenette. Be well.
Thank you.
Okay. We're going to take a quick break here. Excuse me. On the other side of this, I'm being told that there's going to be a press conference with regard to civil rights activists addressing 100 Black jurors matter. We'll be right back. Civil rights activists are gathering for the 100 Black pastors matter that they are going to give a press conference. So we're waiting for that to start, which happened any minute because it sounds like they're getting their mics up and ready and running. But in the meantime, let's go back to a little bit more of Travis McMichael, the shooter in the case, the shooter of Ahmaud Arbery, who testified and then was cross-examined rather extensively by the prosecutor. Let's listen to a little bit of that cross.
That was State's Exhibit 117 that I just published. Now, that particular evening, you've seen the body cam video of Officer Rash, is that correct?
Yes, ma'am.
And Officer Rash told you and told your father that Larry English said Mr. Arbery had never taken or stolen anything from the open unsecured construction site. Is that correct?
My understanding was never saw him take anything from there. Yes, ma'am. Never saw anything taken.
Okay. And Larry English actually had never had anything stolen from the open unsecured construction site.
Yes, he had stuff stolen out of his boat that was inside that house. Yes, ma'am.
But you didn't investigate that crime as a law enforcement officer, correct?
No, ma'am.
Because you weren't a law enforcement officer, were you?
That's correct.
All right. And your father wasn't a law enforcement officer either?
He was not.
Okay. So you're basing your probable cause on something that was rumor that your mother told you about things being stolen off the boat?
I was basing it on the 11th for seeing him in there again and hearing that the stuff was stolen off of that boat, and then hearing it from the other neighbors, and then from seeing on the 11th. So, yes, it happened, and then seeing him come in multiple times, and then everything that followed up on the 23rd, yes, that's...
You were here when Officer Rash testified, is that right?
I was.
Okay, and you heard Officer Rash, under cross-examination, answer the defense attorney's question about if Mr. Larry English had filed a police report about items stolen off of his boat, correct?
Yes.
Okay, and he said the officer assigned would have investigated it, right?
Yes.
All right, and that means interviewing Larry English, correct?
Yes.
All right, so let's go ahead and talk about what was happening on February 23rd, 2020. All right, so you personally first saw Ahmaud Arbery as he was running ahead of you on Burford.
That's correct.
Okay, and you were driving behind him in the white F-150 pickup truck.
Yes, ma'am.
All right, and at that time, when you first saw him, he didn't have a bag, did he?
No, ma'am.
Didn't have a backpack.
He did not.
Wasn't carrying a box.
Was it?
Okay. And you could see his hands as he ran.
Yes.
Okay. And you could see that he was wearing the cargo shorts and the t-shirt.
Yes, ma'am.
All right. And you didn't know who he was. I mean, you didn't know him personally.
I didn't know him personally. No, ma'am.
Okay. You didn't know his name.
No, ma'am.
All right. Didn't know anything about him.
Nothing.
He didn't know you.
Not that I'm aware of.
You just knew that he was the guy who was on video at the open unsecured construction site.
And that I saw on the 11th.
And at this point in time, when you first see him on Burford, he's not reaching into his pockets.
No, ma'am. Not running. No, ma'am.
And he never yelled at you guys?
No, ma'am.
Never threatened you at all?
No, ma'am.
Never brandished any weapons?
Sorry, Your Honor, he's trying to finish his answer.
Yeah, he did not threaten me verbally. No, ma'am.
All right. Didn't brandish any weapons?
No, ma'am.
Didn't pull out any guns?
No, ma'am.
Didn't pull out any knife?
No, ma'am.
Never reached for anything, did he?
No.
He just ran?
Yes, he was just running.
And at this point in time, you're not wearing any sort of uniform?
No, ma'am.
You're not in a marked patrol car?
I'm not.
You don't have any badges on your sleeves?
I do not.
All right, Paul Townsend, trial attorney, is with us. Paul, let's jump into this real quick. I mean, how do you think the defendant is doing on the stand in terms of what his story is and how he held up on cross-examination?
I don't think he held up all that well at the end of the day. I mean, from the clips we saw, you know, he was very respectful and yes, ma'am, no, ma'am, and answered all the questions. But when it came to his testimony side by side with the video that we saw, that's when I really thought his particular version of events kind of had a breakdown. Because, you know, just from me as a layperson, and I don't know how the jury themselves will take it, what I saw just was not consistent with what the video actually showed. So parts of his cross-examination, I felt he did fine, you know, very astutely and accurately, not trying to make more of certain aspects of the case than were actually present, you know, conceding that Ahmaud Arbery was just running up the street when they initially came upon him. But when it came to the actual incident itself, I really thought that that's when his testimony started to deviate from what I think the jurors are going to see on the video. And I think that's where he might run into trouble.
Yeah, okay, and we have, just real quick, folks, I'd asked you to see this earlier. We have this thing where they're trying to establish that there's burglaries going on. It's not just of this facility, it's going throughout the entire community. The McMichaels have been burglarized as well. So they're starting with that there was a previous contact with Ahmaud Arbery 11 days earlier. Now, here's the part that I want to ask you about that I asked AC about. We have a lot of these cases where there's states where there's very open carry laws, carry these weapons. People carry them for their self-protection. They feel in danger about something. They pull the weapon out. Then the person obviously on the other side of the weapon is in fear. And so they may go to grab the weapon in order to defend themselves. and then the person shoots them because they're afraid the person's going to get the weapon and shoot them with their own gun, which, may I add, by the way, and I've gone through the police training commission training, they teach officers about this all the time, that if your weapon gets taken away, you can be killed. So that he was talking in terms of that training, of which he has a significant amount of training. And also, lastly, about how pulling a weapon out sometimes is part of the continuum of force, even if you can't use deadly force, to back somebody down. Did that resonate with the jury at all in terms of his knowledge of those things and those concepts coming across?
In my opinion, it's difficult to say how each individual juror is going to accept it. For me personally, here's where I come down on this. He's obviously got the gun. It's legal for him to have the gun. There's no question about that. But as he's coming across Ahmaud Arbery, his own testimony makes it clear that Arbery's not carrying anything. He doesn't have a backpack. He's not holding a box. He's got a T-shirt and cargo shorts on. He's got nothing in his hands. He's running up the street. So right then and there, you know that he hasn't gone through and looted this unsecured construction site. So that has to be the frame where this whole thing begins. The whole analysis has to begin with he's not actively in the course of running away from a construction site carrying loot. So that doesn't necessarily mean he hasn't committed a crime, but it's not obvious. So the idea then that you're going to pursue him and use a gun to stop him becomes a little bit more difficult to justify. And if I'm a juror, I'm sitting there thinking, your premise is a little bit difficult for me to swallow because you haven't articulated him doing anything in this particular instance. You've discussed running into him, 11 days earlier, but in this particular case, when you come upon him, he's jogging through a neighborhood. You've conceded that. That's all that you've said that he's done. And your response is essentially to pull a gun on him and try and stop him, which leads to this whole tragic situation happening. So if I'm a juror, I'm really struggling, with the whole back and forth. And somebody who has this training understands guns and their inherent danger and how they work and that they are intended to inflict, grave bodily injury or death. The idea that a gun was used in this particular situation, I have a lot of doubts about the propriety of.
Okay, very good, guys. Excellent commentary. As always, we're going to take a quick break here on the Law Crime Network. And as you know, we can't close our eyes for a second because there's a lot going on in these cases. We'll be right back. All right, welcome back. Got a lot of moving pieces going on here today. Felecia, I want to go back to Rittenhouse for a moment because I think this is such an important thing. These jurors were not sequestered. They are obviously able to hear people protesting, and reports have been that they have been nervous about that. And now there's this issue. We don't know all the facts, but the judge came out on the bench. It may have something to do with a reporter following a juror bus, having some contact with the jurors in some way, shape, or form. It's been now elevated to the point that it's been referred to law enforcement authorities for an investigation. Obviously, a grave situation. What is your point of view about all this? How important is it us for society to make sure, at least during the jury trials, that people exercise their rights to remain, to First Amendment rights to speech and assembly, but not affect the outcome of a trial?
Yeah, well, first, shame on that journalist or reporter. He should have known better. I mean, they're still deliberating, so this is still an active case. If he wanted their point of view, obviously wait until after the verdict, and you can speak to the jurors as they wish. But as a criminal defense attorney, obviously defendants have the right to remain silent, but they also have the right to a fair and impartial jury and trial. So in this instance, we don't know which reporter that was and what information he wanted to get and what side of the issues he was on. There's also protesters on both sides. So I understand the apprehension of the jurors because they also made it clear to the judge that they did not want their identity to be revealed. There were some jurors on the panel that definitely wanted to remain anonymous. I do believe that both parties, the prosecution and the defense, vetted these jurors properly, and that they were honest in their response, that they will be fair and impartial. And that also carries over to what's going on outside, that they will listen to the facts and evidence and apply it to the law. So although this incident is definitely unfortunate, I do believe that they are smart and intelligent and will be able to render a just verdict no matter what that verdict is.
Yeah, I think we're going down a real slippery slope lately with these cases that are politicized. I don't care. They use that expression, it's you today, it's them tomorrow. I mean, so there's going to be a case where the other side is going to be advocating for somebody, and there'll be people out there protesting and screaming and yelling and violating that defendant's right to Fifth Amendment right. So that's really, right to a fair trial. But anyway, let's go back to Travis McMichael on direct examination. Interestingly, talked about 2 other occasions in which he had to use or pull out his weapon. Let's take a listen to that testimony.
We were talking a little bit about now moving away from Coast Guard duty and just being a citizen here. Do you own firearms?
I do.
Okay. Have you ever been in a situation where you had to use your personal firearm to protect yourself?
I have.
Okay. Oh, Travis, yeah, put that.
Thank you. Sorry.
Can you tell us a little bit about the circumstances of the first time?
Yes. So I was living in Pascagoula, Mississippi. I was stationed in Mississippi at the time. It was 2008 to 2012. I believe it was 2008 when it happened. Pascagoula got destroyed by Katrina, so there's a bunch of vacant lots and everything. One of them was a bank, and the bank was gone, but they had the ATM machine still in the vacant lot. It's the gas station. Coming through to get cash for, I think it was for the lunch for the station. I pull in, I see 2 younger males next to the side. Thought it was a little weird that they're paying attention to me and been paying attention to people going in and out near there. So I stepped out of the truck and went to the ATM. As soon as I went to the ATM...
Stop you. Did you have a gun on you at the time?
I did.
What kind of gun was it?
It was a 1911 U.S. Army service pistol.
Did you have a permit or a license to carry?
Yes, I had a concealed carry permit, and it was a concealed weapon.
Okay. All right, so you're at the ATM. What happened?
Yep, and as soon as I put my card in, the 2 males approached on either side. One of them told me to give me his money. All I did was pull up my shirt and showed that I had a weapon, and they turned and jumped the fence and was gone.
Okay.
I pulled the money out and went to work.
Okay. Did you call the police or report it?
I didn't call the police on that.
Okay.
That was it.
All right. What is the second time that you had to use your gun? I say use your gun. That time you didn't really have to use it, just showed it.
No, I just showed it. The second one was in Pascagoula as well. It was in 2011. And I was going into work. We had a high value asset coming in. So I was coming in at 8 o'clock. And road I was coming in on it was destroyed by Katrina. It was real dark. Everything was, it was an industrial side of town. And was stopped at a red light, had the windows down in the truck. And sitting at the red light, listening to music on the radio, somebody came to the passenger door and popped the lock and was opening the door on me.
Let me stop you. Popping the lock, meaning was the window down?
The window was down. He just popped it. It was a GMC, so it was right there. He popped it open.
All right.
And opened the door and started yelling. I was getting in the truck. So
what you said, he started yelling?
Yes, I don't know what he was saying, but it was he was yelling.
Okay.
And so I had the pistol between I had a holster between my seats, and I pulled the pistol out and pointed at him, told him to get out of my truck. He got out and ran off. I got to the station, and we had 3 reservists that were actually with the police department there, told about it, and I believe we had a report made on it.
Okay. All right.
KC, I assume what's being said here is that he used that weapon for constructive use of force, which it is called on the use of force continuum. And when the people backed away, nobody got shot. But in this particular situation, it's differentiated because Ahmaud Arbery went after him. What do you make of that argument, the validity of that, at least the jury hearing that?
It can also go against him because he expected Ahmaud Arbery to react like the other 2 incidents. And when that did not occur, who's to say that he didn't panic or, utilize excessive force to get Ahmaud to back away? But we're all forgetting what was going on in Ahmaud's mind. In his mind, he could have felt, you know what, this is an ambush. I have 2 vehicles following me. I see 2 handguns or rifles in this case. So we don't know what was going on in his mind, coupled with the expectation that Ahmaud should have stopped as soon as he showed his pistol. So, I mean, it could work against him in a juror's mind.
Yeah, excellent analysis. KC, I'm told you've got to leave. So I really appreciate you once again coming on the show. We've got a lot to cover. We have that civil rights conference. It's going to be the 100 Black pastors, and we have the trials to cover. So don't go anywhere. We got a lot more. Please stay with us. We'll be right back. Okay, we got a lot going on in Ahmaud Arbery. Earlier today, the prosecutor asked a question on cross-examination of one of the witnesses that, do you believe that stealing something is deserving of the death penalty? Rising the ire of the defense attorneys who objected to judge sustaining it. They want to file a motion, and they've got motions for mistrials already out there. And basically, the court said that they found that the question was, in fact, inflammatory and irrelevant and not necessary. And, quote, counsel is admonished by the court, and the judge will actually instruct the jury that the prosecutor has been admonished. So that is really something that's quite amazing and takes a nick out of the credibility of the prosecutor in this case. You never want that to happen in a courtroom. Let's listen live in the court and further motions and arguments that are being made so far, which is really unforced errors by the prosecutor.
Any questioning of a witness about something she read in the Brunswick News. The Brunswick News says, hey, a serial killer has just escaped from the Brunswick jail, the Glynn County jail. Everyone lock your doors. Well, maybe it's right, maybe it's wrong, but it sure does inform the decisions they make and the thought process that they have. For that reason, Your Honor, so long as the proper foundation is laid, the defense contends that we ought to be able to question and allow our defense witnesses to testify about things they saw, things they posted on Satilla Shore Facebook page, and how those things they saw and posted informed their decision making.
Anything from the state?
Yes, Judge. First off, Travis McMichael was shown Facebook posts that he made. And that he responded to and that he commented on. So that doesn't really go to that argument. The problem here is, how is it connected to Travis McMichael? Travis McMichael testified appropriately that I looked at Facebook and I thought there was an uptick in crime. That's his perception, that's his opinion, and that's before the jury. So that's fine. But putting Miss Lindy Kofer up, which they just did, who said, I've never been the victim of a crime, and yes, I would repost other people's things on Facebook, there's been no causal link between what she did and her Facebook postings and Travis McMichael. There's been absolutely nothing that connects the two of them that makes it relevant. And her perception and opinion, now, if she had taken the stand and said, yes, I saw a Facebook post and I went out and put up cameras, or I was the victim of a crime and put up cameras in the neighborhood, as we assume some of the witnesses are going to testify to, yes, that's what that person did. But to solely go, I read Jenny's Facebook post and Stevie's Facebook post and this other person's Facebook post, and this is what they said, well, that's hearsay. And that's basically not admissible evidence at that point. So I'm not sure what the defense is asking for these witnesses to do. I think at this point the suggestion is, we see if it's hearsay. We see if what the person's talking about is their personal Facebook post, or is this something they read? Because we're going to bring in every single Brunswick newspaper and show it for all of 2019 and 2020 to inform these people. They all read the newspaper. Maybe they watched the nightly news. How does that connect up to whether it's more likely or less likely that the defendants committed the crime? So we ask it to be more on a play-by-play basis, because I think that's the appropriate way to approach this.
Agree with that, except let's see if we can all agree on the definition of hearsay. Hearsay is not a Facebook post if it's not being offered for the truth of the matter asserted, but instead to inform an individual who has read it or posted it, and who will do, just as you said, Ms. Donikoski, will testify about how that affected one's perception of their neighborhood and may have caused them to take certain additional safety measures or constrain their own liberty as a result of what they've read.
Yeah,
Your facial expression makes me think that we're not on the same page.
No, I'm trying to figure out how to explain where I am on it. The objection that was made during the last witness, the court sustained the objection and actually explained the ruling. She was asked generally about, I didn't write it down, but generally about Facebook posts and what her thoughts were. But my ruling, I indicated that I think it was a relevance objection, was not relevant to the defendants and what they may have known, and none of that got linked up. So for that particular objection, if I remember correctly, that was the basis for it. The challenge with the Facebook posts is it's social media. I'm not sure exactly what the basis of it is. There are some issues that are out there, so the court has some concerns about a bunch of Facebook posts being the basis for anything. But more importantly, what we're here about is what the defendants think was going on, as opposed to with the last particular witness, what a resident of 30 years may have seen and how she reacted to it. The court has some concerns about the relevance of that evidence, and I'll rule on it accordingly. But just putting up individuals that live in the neighborhood to say, I looked at Facebook and this is the way I felt, I think that there's the basis for some objection there, and I'll go ahead and take that as they come. But if it can be linked up with what's actually before the court, so be it. But just bringing witnesses in to say they looked at Facebook and unrelated to, in fact, she testified, I think she didn't know the defendants. That's correct. Yeah.
And I'll just say this last piece, Your Honor, to fill in that one gap. We will link this up. And I think it's important for the court to be reminded that during the cross-examination of Travis McMichael and other direct examinations of GCPD and GBI agents, the argument has repeatedly been made by the state that the defendants are exaggerating the feelings of that neighborhood and what was really going on in that neighborhood. So I think the only way to respond to that, if I'm acting on behalf of myself and my neighbor, then it's fair enough for me to say, well, let me tell you what my neighbor was worried about. Here's what she told me. Here's what she experienced. And that may help the jury think more clearly about the way that the state is characterizing a peaceful, calm, placid Satilla Shores in February of 2020.
I just want to add, I'm sorry. I just want to add, I think Ms. Hogue addressed it, but several witnesses have testified that there were maybe 2 burglary 911 calls or 2 entering auto 911 calls, 1 burglary call for this long period of time. That testimony was elicited by the state. The only way to respond to that, there was more crime in the neighborhood, is from people who experienced it and read about it and were concerned about it. And that's the relevance of the Facebook page, because Travis McMichael testified on direct.
Well, let me just, I guess I was going to say, I don't mean to cut you off, but I'm going to do that anyway. Yeah, I mean, if you got a witness that stands up and testifies that they were the victim of a crime in Satilla Shores, sure. But if you got a witness that gets up and says, oh yeah, I lived in Satilla Shores and I looked at a Facebook page and I used that to inform myself about crime in the neighborhood, but I've never spoken to the defendants, which is exactly what we had with the last witness, that's an objection that's going to be sustained. Those are 2 very different things. Okay. All right.
I mean, we believe, because of Travis McMichael's use of the neighborhood Facebook page as a source of information that raised concerns that he testified about.
Well, and he testified, and on direct could have walked all the way through that. So and I believe he testified to what he was informed of in the neighborhood, and Facebook was referenced during his direct examination.
Correct. And this corroborates that there were, in fact, Facebook posts about crime in the neighborhood.
But the
from the
I'm not going to debate it. The question that went beyond that into what the Facebook posts were, and so again, the objection was sustained with the last witness. I've explained where the court generally is on this, and we'll proceed from there. All right, we're going to bring the panel in. I'm going to provide the instruction to the panel, and is Travis McMichael ready with his next witness?
Next witness
His next witness.
Cindy Clark.
For the record, on the recess for lunch, we had a individual out in the foyer of the courthouse wearing a Black Lives Matter mask, bringing it to the court's attention. For the record.
Okay. All right, let's go get the panel.
Well, Paul, I don't even know where to go first. I mean, prosecutor's going to be sanctioned in front of the jury, which I think is an appropriate move. An excellent argument made by Law Haug, I believe it's pronounced. Wow, what a good lawyer. And a very interesting ruling by the judge that I think got wrong. But now I just want to go to that last thing. Now we got this person wearing the Black Lives Matter mask. It's just getting to a point where the courts are not asserting enough control to ensure that these things don't happen to impinge on a defendant's trial. And I don't care if it's this trial or if it's somebody on the other side you don't like. This just isn't right.
Yeah, I mean, there's obviously a lot just went on. So let's take it, piece by piece. The judge sanctioning the prosecutor in front of the jury, absolutely the right move. The question was over the line. The prosecutor knew it was over the line, asked it anyway. There's a decent chance that question is going to resonate with the jury. I do think that sanctioning the prosecutor and giving the curative probably is sufficient. I don't think it warrants necessarily a mistrial, but I certainly understand the defense's position in asking for it because it really was far beyond the bounds. With regard to Ms. Hogue, I think that's what it is, and her lawyering, it is a pleasure to see good lawyering. I completely agree. Too many attorneys on both sides do not fully understand the hearsay rule, and she does. And she was able to perfectly articulate why these Facebook posts are not hearsay, because they are not being offered for the truth of what the posts say. They are offered to explain Travis McMichael's state of mind, which is a non-hearsay use, and it's perfectly admissible for that purpose. I agree with you that the judge was not fully comprehending the argument and should not have been so quick to deny it. I think that the posts, as they impacted his state of mind, which is front and center issue in this trial, absolutely was fair game. And with regards to this attorney continually bringing up, issues about Black Lives Matter, the judge has to rein this in. This cannot continue. We can't have, just for the record. It is getting outrageous. So I think that this judge needs to really start taking control of this courtroom.
Yeah, and going back to the substantive argument that was being made about the Facebook post, which I completely agree with the defense, and as a prosecutor, I wouldn't have objected to because I don't want to create reversible error in my case, is that it's what his state of mind is. And even the community state could explain the actions of not just one defendant, but all three defendants in the case, because it also went against the narrative that the prosecution witnesses put on to say that there wasn't really a crime problem in that area. But apparently the community felt otherwise. And so that is relevant if the defendants were aware of what it's almost like reputation evidence. What's their reputation in the community, not specific instances of conduct. What are your thoughts on that?
Yeah, I agree. So what we're looking at here is kind of what is the community's current reputation. And it certainly does go to the collective state of mind of all three members of this community. I think the defense attorney made an excellent point when she brought up the hypothetical example of, a serial killer breaking out of prison. They don't need firsthand knowledge of the fact that a serial killer broke out of prison. If they read about it, and it informs their decisions on maybe I lock my door tonight, maybe I don't go out on the street after 8 p.m., then it is affecting their state of mind. And that is a perfectly reasonable use for that. They are not saying that the Facebook posts are true, that these crimes absolutely happen. What they are saying is that crime is up, and that impacted how Travis McMichael's mind was working at the time. And that is 100% a valid consideration in the case, and the prosecutor bringing up the contra evidence of that on their case just makes this ruling even a little more repugnant to me, because they should know that the defense is entitled to combat that assertion.
I think it goes more to Brian, by the way, who's videotaping this, not the videotape of a nefarious, hateful thing, but trying to gather evidence because of what the community was thinking. I don't know. I don't know why the judge didn't permit it. Anyway, I'm told we can go live to court to listen to the judge speak to the jury, so let's go to it. It looks like a good time for a break. There's going to be a new witness coming on the stand. We're told that the judge has already admonished the prosecutor in front of the jury, so we're going to be right back. Stay with us. Welcome back. Travis McMichael's attorney has Cindy Clark on the witness stand. She's from the Centilla Shores neighborhood. Indicated that there's crime in the neighborhood, car break-ins, guns stolen, people walking around at night, that they took precautions. And she was also a member of this Facebook page that they had. Let's go back live to court.
Miller versus the state, 258 Georgia Act 425. May I approach? Yes. Mark the last paragraph for the court, asking a question that contains the possibility of it. I'll read it. I was just making a record for the court. That's fine.
It restates what a leading question is.
I know. I'm just giving it so the court understands that asking the witness a question that contains the possibility of a yes or no answer is not a leading question.
To counsel testifying and counsel doing all of this with a speaking objection.
I was just responding to the objection.
Okay. This is
helpful?
Well, no. It states what a leading question is. If it suggests the answer, then it's leading.
Right.
A leading question can still be phrased as a yes or no, as if it leads to one and only one of those answers as a conclusion. It is still leading.
I would say it's subject-driven, but I understand the court's ruling. I'll move on.
Yeah, so let's go on. It's sustained.
Okay. All right. Did you yourself witness any type of crime happening in the neighborhood or become aware of it in your own space in the neighborhood?
I didn't witness it.
Did you witness any aftermath of it or anything suspicious at any time?
Yes.
Can you tell us what that is?
The neighbor across the street, I guess they were in the middle of going through their car. And
who's they?
Okay. It was two guys that were in a car that had parked across the street from my home. And I guess they scared them, and the one guy drove off and left the other guy in the neighborhood. And that was around like 2 or 3 o'clock in the morning, so we all woke up, they woke us up. So I was aware of that.
Okay. Is this the kind of thing that you would post for the benefit of other neighbors?
I don't think I posted anything about that. There was another incident that I posted about because I saw some people in the neighborhood. A car broke down, people walking into the neighborhood, and I did post about that, but I had called 911.
And why did you post about that particular incident?
Well, they were walking into the neighborhood away from their vehicle instead of walking out of the neighborhood maybe to get help or something, but it turned out to be a stolen vehicle. So
okay. Are you yourself a gun owner?
Yes.
Okay. If you could just give me one moment. Your Honor, one moment, please. questions. Thank you.
Okay.
But you'll just have to wait 1 second. The state might have questions.
Hi, Ms. Clark. How are you?
I'm good.
Good. I'm Linda Dunikoski. I'm one of the prosecutors, okay?
Nice to meet you.
Nice to meet you, too. So, this incident with the two guys across from your home in the middle of the night, when did that happen?
I can't remember the year.
Well, let me ask you this. Was it before COVID?
Yes.
Okay. So if we do that, was it like the 2019, 2018, or even further back?
I think it was further back.
Further back. And then when we talk about that car that was broken down, was that the car from Florida that was stolen?
Mm-hmm.
Okay. And so that was, what year? Do you remember when that was?
I'm going to guess.
Okay.
Maybe 2016, something like that.
All right. And do you know Greg McMichael or Travis McMichael?
I don't.
Okay. Do you know Mr. William Roddy Bryan?
I've met him one time. Mm-hmm.
All right. Thank you very much.
Any regret? Speaking about dates, do you recall in December of 2019 learning about a suspicious car coming in the neighborhood and you saying that you would go back and get the tag number of
Yes.
the car? Is that kind of the way you're talking about trying to help neighbors?
Yes.
Okay. Do you recall around August of 2019 sharing some suspicions about an individual who was taking pictures and walking around the neighborhood taking pictures and that someone should run his license plate too? Can't remember that one?
I can't remember that.
If
I didn't remember that one.
Okay, may I approach the witness? See if it just refreshes your memory. You're welcome to step forward. So just see if that refreshes your memory about
Yes.
generally saying in August of 19 about another car coming in, maybe
Yes.
running the license plate.
Yes.
Again, is that something that you were doing to try to be a helpful neighbor? Okay, that's all I have. Thank you.
Okay.
All right. Thank you, ma'am. You may step down. You should be released.
May be released.
All right, and you are released. Thank you.
Paul Townsend, obviously why the defense wants to get this stuff out. This one went smoother than the first witness. How effective is this kind of examination in front of the jury about the crime issues in the community?
You know, I don't find it to be all that compelling about crime issues. I think the redirect kind of helped, and I don't think that should have been saved for redirect. That was stuff that should have been in the direct. But they basically brought up two incidents, that were 5 years ago or so, to try and paint this community out to have a crime problem. If they really wanted to be effective in making this out, there should have been more. Even if she couldn't testify as to specifics, they should have tried to elicit, was there an ongoing problem? Was this something that you heard about on a regular basis? Something that would have established that, yes, crime is in fact really a problem at Satilla. But it just seemed more like this was kind of almost grasping at straws, putting someone on to kind of say, oh, yeah, 5 years ago, we had somebody break into a car across the street. Like that doesn't indicate to me that the neighborhood is unsafe. It needed to be more for me.
Okay, great. All right, Paul, we're going to take a quick break here on the Long Crime Network, and we'll be back with more. Please stay with us. All right, welcome back. We now have a new witness on the stand, Brooke Perez. Her husband actually assisted Gregory and Travis McMichael during the altercation on February 11th at the construction site where Ahmaud Arbery was there. So there's a big part of the defense case. But she's testifying right now to her own home having been, her car being burglarized, and then putting camera systems up because of crime in the community and how unsettling it was to her. Let's go back live to court.
I don't.
Okay. Was it prior to 2018, if you know?
It might have been. It may have been. I really don't know.
Well, tell the jury why you posted about a personal theft of you and your husband's tools.
Well, if I was a victim, I'd assume someone else, in the neighborhood was, because that's how I found out I was a victim, was someone had said someone had entered their car last night, and I said, this needs to stop, where the car is locked, and then come to find out we were, theft, and apparently his truck wasn't locked. I'm not sure what happened, but just to let them know, hey, something was missing from us, you might want to check too.
Okay, so you were letting your neighbors know about your own theft?
Yes, sir.
Okay. Did there come a time when you became the administrator of the neighborhood Facebook page?
Yes, sir.
And why did you become the administrator of the Facebook page?
Because my lovely neighbor made me administrator. I guess because I'm usually home, and I don't say I sit and watch the cameras, but it's a huge 40-something inch screen, and all you have are all these cameras that show, so if there's motion, it'll let you know there's motion, and it'll tell you what camera, and I kind of look to see, what's going on.
Okay. What does being the administrator mean for people who aren't on Facebook?
If you wanted to join the group, we would see who it is, and if they lived in the neighborhood, yes, here you go, and that's.
So the sole criteria of being on the page is you have to live in Satilla Shores.
Yeah, absolutely, or either. I think my mom's on there, and a couple of other, relatives, to look out. So if we were out of town, she would know, hey, there's something going on, they're not home, that kind of thing. But
as the administrator, how often would you look at the neighborhood page?
On Facebook, it'll give you a notification if someone's posted in there, and so I would look at my phone, periodically, and if I saw a notification, I'd go and then go on there and look.
Do you think you looked at it once a day, more than that, or less than that?
When someone posted on there, so sometimes there's more than one post a day, and sometimes, there's, several weeks that there's not a post, so it would just depend on the action.
Please tell us the kinds of things that people use the Facebook page for, the neighborhood Facebook page.
They would use it for if, we had an incident as far as a theft, if a suspicious person, if our water went out, if power went out, if, police activity in the neighborhood. Basically to keep, whatever is going on in the neighborhood, to keep, our neighbors informed, because a lot of our neighbors are elderly neighbors, and there's several houses that are, I don't want to call them weekend houses, but basically no one lives there full time. They're there maybe a weekend a month or so. So that way everyone kind of knew what was going on.
Was it a way of keeping an eye on everybody's property and other things going on, the kids and things like that? Okay. Did you keep Diego informed about the things you were seeing, Diego Perez, the things you were seeing on the neighborhood Facebook page?
I think I told him about the water a couple times, and I did tell him any time that there was suspicious activity, and anytime something would go missing, I would let him know.
And why would you tell your husband about suspicious activity that you were seeing being posted on Facebook?
Because he's my protector.
Okay, so to keep him informed about the things he needed to know to keep you and the kids safe?
Yes, sir.
Okay. Do you know a gentleman by the name of Larry English?
Yes, sir.
How do you know Mr. English?
Our kids, so we bought the fun house in the neighborhood for all the kids to come to and hang out, and he has a young son that's in the same age as my oldest daughter, and the kids across the street, they all would come to our house, and his son Hoyt, he was outside playing, and I said, ask your dad to get your swimsuit and come swim with the kids, and he said, no ma'am, he won't let me, but if you come down there, maybe he'll let me. So we walked down there, and that's how I met Mr. English and introduced myself. Hi, I live right here. Our kids always play outside. If it's okay, can he come and play? And that's how I met him originally. And
how many doors down from you does he live?
2.
And I mean, when I say live, Do we understand this to be a house under construction?
Yes, sir. He lives in a camper in the backyard.
Okay. So how often would you know Mr. English to be on his property, approximately?
Still to this day, about every day, every other day. I see him all the time there. And since the house was being worked on, he's there working a lot. So
on the house?
Yes, sir.
Okay. Did there come a time where you informed Mr. English about you and Diego having your tools missing?
Yes, sir. The day that the cop, came out, the day that our tools went missing, my husband said, there's a gentleman over here building a house. You might want to check with him. And my memory serves me correct. Diego and the police officer walked over there to Mr. English's house, and I think that's the first time that they had met each other.
Is that the first time you met Mr. English?
No, sir. I didn't go over there with the police. I met him, I think it might have been right after that, or maybe it was right before, but it was with the kids playing.
Was there ever a time where you became aware of problems Mr. English was having with intruders on his property?
Yes, sir.
And do you remember when that was?
I believe that might have been in October.
What year?
Maybe 2019. And I only know that because a neighbor had phoned and said that someone was on her camera. She wasn't home. And so I woke up my husband, hey, there's someone on the camera, go and check. And I spoke with police that night.
All right, so
and the police officers who told us about that.
All right, let's back that up. So there was a time where you became aware, I think you said October
Yes,
of
sir. I believe it was in October.
Okay. How did you become aware of an intruder on Mr. English's property?
I can't say if I saw on the camera the cops or if it was when Diego was outside the cops, but I know I was alerted due to police presence, and I remember speaking to an officer, and he said that they were looking for a young black male that had been on, and he didn't tell me whose property, but pointed at the house under construction, and that the caller had said he had ran across the street to the house across the street from us.
And you said you got a call from a neighbor that night while this was supposedly happening. Who was the neighbor?
Miss Lawrence.
Subi Lawrence?
Yes, sir.
Okay, and she called you?
Yes, sir.
And do you know, without telling us what she said, do you know why she called? Did she inform you, without saying what she said, of what was going on at her house?
Yes, sir.
Okay. You mentioned Diego being outside. What did you do after you got a call from Subi Lawrence?
I immediately woke him up and I was like, honey, there's someone on Subi's camera, and he jumped up and busted his tail. We have hardwood floors and he was wearing socks, and he slipped and fell and then jumped up and went out, went over, and he never found anyone.
So literally busted his tail?
Yeah, literally busted.
Fell on the floor.
Yeah.
Do you know if he went over there, when he went over there, he was armed?
Yes, sir.
How do you know that?
My husband's normally armed. He carries every day in his waistband, so.
Has a concealed weapons permit?
Yes, sir, and we have USCCA. So.
Okay. So he went over, to your understanding, to Ms. Lawrence's house?
Yes, sir.
To try to help her understand what was happening on her
she wasn't home, and she's a single mom with 3 small children. And when she called and said someone was on her camera, it was like, oh gosh, so I said, don't come home until we make sure everything's okay, because the last thing we wanted was someone to be in her house and, her and the little boys go in, and who knows what would happen.
Did you eventually go outside and I think you said talk to the police?
Yes, sir.
Okay. Was, to your knowledge, anyone found, located, that had been the intruder at Mr. English's property that night?
No, sir.
Did there come a time when you became aware of other nighttime intruders in Mr. English's property?
Yes, sir.
And how did you become aware of that?
Mr. English would text my husband, usually a video, and sometimes he would call and say, how would he say, the colored man's back at my house.
That's what he says?
Yes, sir.
Okay.
Or the colored boy is what he would call and tell Diego.
Okay. And why did he call Diego, to your understanding?
I know my husband told him we're 90 feet or 95 feet something. Our house is, may seem like far, but it's not. And he told him, goodness, because Larry, I think, had sent him some pictures or whatever, and he said, if you need me to respond, I can. You know, I can pin them up. I have night vision goggles. You know, until the police can get here to see who this is. And
so your husband was leaving your house to go respond to Mr. English's problems?
Yes, sir.
Okay. Did you ever try to stop your husband, say, this is not our concern, don't do that?
No, sir.
Why?
Why not? Sorry.
It's dangerous, right? It's dangerous.
I mean, it could be, yes, sir, but if you don't know what, you're just going to find out, hey, what are you doing? What's going on here? That's not, it could be dangerous, yes, but it could not. So I didn't look at it as...
Did it not scare you when your husband would leave the home at night to go check on the streets?
It was very unnerving that what was going on, because you didn't know what was going on, but I guess I trusted my husband enough, and I knew, you know, that I guess the Lord would protect him. Whatever he felt right as a husband and as a leader of our home to do, then that's what he should do.
Okay. How or what, if any, actions did you take once you started hearing about multiple intrusions in Larry English's property 2 doors down from yours?
I messaged his wife on Facebook and asked, can we put up some no trespassing signs?
Who's Larry English's wife?
Larry English's wife.
Okay.
And ask, you know, hey, can I put up some no trespassing signs? Maybe that'll deter, you know, if you don't know, maybe if they see a sign and realize, hey, this isn't just, you know, a random person building a house, it is an actual family building a house. Maybe that would deter something.
Did you ever call any of your surrounding neighbors to let them know that this intruder was here?
Yes, sir.
And could you tell us who you talked to about that?
I called Subi Lawrence.
Okay, single mom of 3.
Yes.
Across the street. So you and Subi were friendly beyond just neighbors?
Our kids went to daycare together, so I've known her for a long time. So yes, sir, I would say.
Okay. Did you ever post about the intrusions in Larry English's house, the break-ins in his house, on the neighborhood Facebook page?
I'm sure I have, yes, sir.
Okay. Give me 1 second. If you'll turn to page 356 and see if that refreshes your memory about it.
Brooke Perez on the stand, the administrator of the Facebook page that there's been so much discussion about. We have Mike Corey-Bannock with us, a law and crime analyst, certified criminal trial attorney, former prosecutor, defense lawyer, and friend. Mike, I personally, I know there's been a little bit of a slow start here with the Facebook issues and the community and what they knew and didn't know, but it's coming together for the defense, and I think very clear to the jury that there was an escalating and ongoing problem with crime in that area, to the extent that they had a Facebook page put up there. They have surveillance cameras that are going on there. People are taking protective measures, and specifically with regard to the property, that Ahmaud Arbery was out on at least 2 occasions. How effective is this for the, or why is the defense doing this? Give us that explanation.
Well, I think what the defense is trying to create here is that everybody was sort of worried about these burglaries, things of that nature. I really am not sure, though, how this cuts, Bob, because I don't know how the jury is going to really interpret this. And as you've pointed out before, different communities are used to different things. I mean, you know, like you said, we're very strict gun laws. It's very shocking for us to see a person with a gun. We almost immediately assume there's a crime if we see someone with a gun in New Jersey. The thing I don't understand with the defense here is, with all these precautions and the police knowing about it, why did anybody have to take the law into their own hands when all you needed to do was pick up the phone and say what was going on and have trained law enforcement handle the situation? That's where I think it could backfire on them.
Yeah, I think the answer to that's going to be that law enforcement wasn't able to do it, that they were availing themselves, I believe, and we'll see if there's more of that comes out from the defense attorneys, including on the February 11th incident. They contacted 911, but you know, that supposedly was one specifically with Ahmaud Arbery, catching somebody that's doing something maybe difficult for police in certain circumstances. Anyway, we'll see what the defense brings out. We're going to take a quick break here on the Law and Crime Network. We'll be back with more. Please stay with us. All right, welcome back. Brooke Perez is on the witness stand. Very important testimony. She said that somebody was breaking into Larry English's house that was being built. Again, that's the scene of the location. on February 11, 21, and that she went outside with a gun in her hand. Defense lawyer asking why. She carried the gun because she doesn't know what she's going to encounter, fitting right into that defense theme. Let's go back live to court.
Person, it would really be suspicious, but not like alarming. The same person coming over and over and over, it just made me, worry. Why is the same person coming over and over and over?
And it alarmed you because what were you thinking was happening?
I really didn't know what was happening. I assumed Mr. English didn't know who he was, and he had no business there, according to him, and that was his property. And he had told us, prior to that things had gone missing. So I just assumed the same person coming over and over and over, and you've had thousands of dollars of stuff missing. I assumed that it was the guy that would keep coming back.
So you put these various pieces together and made an assumption?
Yes, sir.
Okay. You didn't see him steal anything, this black male intruder?
No, sir.
But from various pieces of information, you drew a conclusion?
Yes, sir.
Were you home on February 23rd? During the shooting?
Home. No, sir.
Okay. Where were you and your husband?
We were at church. Our church, St. Simon's Community, was building a new campus here in Brunswick, and we were donating our time to build our pastor an office in the church. So after church got out, we went and had pizza. We got new windshield wipers, and then we went to church. We did some drywall mud, and then went home.
When you got home from church, did you find out about the shooting of Mr. Arbery?
I was pulling into the neighborhood. A cop come hauling tail in, and our neighborhood's quiet, mostly older retired people. And I was like, what the heck is going on? So I got off, the side of the road, and he come flying on in. And I told my husband, I said, we're going to go and see what in the heck this happened, what's going on. So I drove around past our house, and that's when we came up on
the scene.
Yes,
right,
sir.
Right. Did you see Travis McMichael out there?
Yes, sir.
How did he look to you?
I don't know if scared, he looked just not himself. He just had his hands up, and he was just like, and I was like, what in the world? When I came up on it, I didn't know what happened. Didn't know what in the world it transpired to go on, but he was bloody, and he was just like pacing back and forth. And then I remember he just like kind of plopped himself down. They had like a tree that was pretty tall, and he just kind of like sat down and just kind of looked frazzled. And it was like, what the hell, I think is what I said.
Okay. Did you stick around?
No, I drove on. My husband said, he's dead, go. And we had our kids in the car, so.
Do you know if your surveillance cameras captured Mr. Arbery from that date?
Yes, sir.
Do you know what happened to the surveillance camera video from your house?
Diego put it on a USB and gave it to a cop on the scene that day.
Okay. That's all I have. Thank you, Ms. Perez.
Yes, sir.
Stay.
Judge. Hey, Mrs. Perez, how you doing?
Good, how are you?
I'm good. We've met before and talked, haven't we?
Yes, ma'am.
All right. So, on the 23rd, you own a black car, right?
Yes, sir. Oh, yes, ma'am. Sorry.
It's okay. You can call me sir.
No.
But you were coming in, and Officer Duggan was speeding right past you.
Yeah, somebody.
Okay. And you went down. Diego said, no, keep going.
Yeah.
All right. So you took the kids home.
Yeah.
But he wandered on down to the scene, didn't he?
Yeah, he wanted to, what in the heck? It was a pretty gruesome sight to come up on, so he wanted to know what happened.
All right, now, let's talk about, I'm going to kind of back up and we'll talk about crime for a minute, okay? Now, you guys had never been the victim of crime up until this June 30th, 2019, when the tools got stolen out of the unlocked car in your driveway, right?
Yes.
All right. But you guys normally locked your cars, right?
Well, see, that's the thing with his truck. It actually had to go to the shop.
Paul, this testimony is substantively better than the other witnesses the defense put on for what they're trying to do, which is explain why the McMichaels went after Ahmaud Arbery.
Yeah, there's no question that Brooke Perez's testimony is far more beneficial to the defense than Cindy Clark or some of the other neighborhood people that they have put on. Perez has been able to much more kind of all-encompassingly describe how the community had been experiencing certain break-ins and crime, and the focus kind of moved away from this individual one-on-one, one-off thing to more of, she as the administrator of the Facebook group kind of had her finger on the pulse of everything that was going on. And so she's able to really kind of set more of an ambiance rather than a singular issue or one-off situation. And I think she's done a very good job of kind of explaining how the community itself was responding to specific instances of crime, but also to just the elements of crime in the area in general.
Yeah, definitely. And with the other witnesses, when you combine it all together, I think that the defense is showing the jury that at least this was an issue in the community. May very well explain why it was that the defendants did what they did. Not that it's necessarily self-defense. That's the next piece. We're going to take a quick break. We'll be right back.
Watching Law and Crime.
Ooh, man, things are heating up here at this Law and Crime Network. I got to tell you what, we got Angenette Levy with us in Kenosha, Wisconsin. Our boots on the ground out there with these most unbelievable developments. Angenette brought us a little bit of what went on about, do I understand, an MSNBC has been banned from the courtroom?
That's right, Bob. Judge Bruce Schrader has ordered that MSNBC not be allowed in the courthouse for the remainder of the trial. This comes after apparently Kenosha police stopped a man named James Morrison for a traffic stop yesterday, and we are told by NBC this was a freelance journalist. It sounds like working for NBC, and the judge was on the bench, and he talked about how this person told Kenosha police that he was told by someone in New York from NBC to follow the bus. Kenosha police ticketed him for a traffic violation, and the investigation remains underway. So NBC News, I reached out to their people, and they released a statement saying that this person was cited for a traffic ticket. He was a freelancer, and that they are cooperating with the investigation. So that's the very latest. A very serious matter. If somebody's following a bus, there was an allegation earlier in the trial that someone was photographing jurors, and that somebody in the media apparently, but which is a huge no-no. Leave the jurors alone. You do not bother the jurors. You do not approach the jurors until the end of the trial.
All right, Angenette, we have pending right now a motion for a mistrial with prejudice because of commenting on the defendant's post-arrest silence. We have another motion that's been made for a mistrial. We're told that there was video evidence that the prosecution had that was clearer than that in which the defense had. And now we're hearing, is it true that Jump Kick Man is allegedly been identified? Is that something that's recent, or did prosecutors know about that too and didn't disclose it?
Well, the identity of Jump Kick Man, that seems to be a recent development. So he has apparently been identified. There are some media sources, media outlets reporting that they've confirmed with this person that he is indeed Jump Kick Man. And, when the prosecution identified him, we don't know. But through the trial, they were saying he was unidentified. And there is a charge pending against Kyle Rittenhouse for that. And, the jury, obviously, just to bring our viewers up to speed, they are still up there deliberating right now.
Angela, just one more quick question I got to ask you. Is the sensibility out there that the judge has reserved on the motion for mistrial on the post-arrest silence because he wants to wait to see if the jury comes back with a not guilty verdict first, but if they don't, no? Why did he do it then?
No, that's not it. He actually addressed that yesterday. He said that the motion, obviously the motion for mistrial with prejudice was made orally last week. It was filed on Monday. He said yesterday he didn't get a copy of it until Tuesday, and he can't respond to that until the prosecution responds to the motion, which they haven't done yet. So the judge was kind of upset. He said that someone wrote a story that he was sitting on the motion and he was, delaying this. He said No, that's not true. And he didn't even read the motion, he said, until a break yesterday after he had brought this up in court. And then there's a second motion for a mistrial without prejudice over the whole drone video issue. And Bob, before we go, I do want to show you guys something else, if that's okay.
Well, just one question on that before you show us. What happens, though, if the jury comes back with a verdict before the judge rules on the motion?
That's a very good question. We've all been wondering that. But the prosecution, other than saying they oppose that orally in court, they haven't filed a written response to any of these motions for mistrial. And actually, the one yesterday over the drone video, that was made orally. That hasn't been filed in writing to date.
Wow, unbelievable. What do you got to show us, Angenette?
Okay, Bob, this is what I want to show you, because it's been kind of tense out here the last couple of days. We saw that we had a fight out here yesterday. 2 people were taken into custody for disorderly conduct and battery. Well, guess what? To kind of make everybody a little bit happier, it's freezing out here. I think this is a really great gesture. The sheriff of Kenosha County has set up this table over here. Let's pan over here. Coffee from Dunkin' Donuts and cookies. Let's give a shot of this. This is the Dunkin' Donuts coffee. Got lots of coffee out here. And then we've got the cookies for peace. That is what the sheriff is calling that. And I want to come and talk to the sheriff about this and why he did this. Sheriff David Best of the Kenosha County Sheriff. Sir, thanks for joining us today. Tell us about your cookies for peace.
Well, I want the county of Kenosha, the city, the Wisconsin, really the entire country to know that there aren't that many people here. There's about 30 people here, and our goal is to keep people safe, to keep them, to relieve some tension, if that's what it boils down to. But even the sheriff is willing to come out here in this group. Whether they're a little loud and vocal or not, that I'm willing to come out here and be part of what they want to protest and what they want to say, and say we're here to support you and protect you, and hopefully this keeps any disturbances from happening.
How concerned are you when the verdict comes down, that there could be, obviously it's really cold out, maybe that's impacting the number of people who are out here, it's the daytime, people have to work, but are you concerned that there could be some violence?
We're always concerned. I mean, we live in a community where violence does happen. So could it happen? Absolutely, it could. We're prepared. We've been preparing for this for a couple of months, and we've got people on standby. But all of our intelligence says we're not going to have a lot. And actually, other places of the country are more concerned that violence is going to break out. But a little while ago, I just walked through the small group that's here, gave them all cookies, and they thanked me, and they went back to their chanting, and it's kind of funny. But if I can feel safe walking through this group handing out cookies, I think pretty much everyone in the country should know that if this is as bad as it gets for people voicing their opinion, it's not too bad.
And we've been walking through that crowd all week, and I haven't felt uncomfortable once. So, but I have a pretty thick skin, if you would, for that type of thing. It doesn't really bother me that much. Well, Sheriff, thanks. We're glad to hear that you guys are prepared for anything. Do you even think the National Guard would be necessary? You're saying your intelligence is telling you you're not going to have a lot.
Everybody that I've been relying on for what's been going on in our area has been saying that they're hearing nothing. I think a lot of these people here are actually from out of town, and I truthfully don't believe there's going to be a lot of reaction here in Kenosha. Maybe for a short time. After that, this is going to come to an end, and I'm hoping that really throughout the entire country that's the exact same thing. No matter what the decision is, people are going to like it, people are going to hate it, most of the people aren't going to care, and having any kind of violence or anything like that or protests, it doesn't solve anything. So if this is the extent for the entire country of protesting, I'm good. It's here. These people are really pretty good people I've met so far.
All right. Sheriff David Best of the Kenosha County Sheriff's Office, thanks so much for talking with us and joining us for our live shot today. We appreciate it. All right, Bob, that's it from Kenosha right now. The jury is up there deliberating still. We've got cookies for peace and Dunkin' Donuts coffee. If I could, I would kind of teleport that to you, but I don't have that capability, so you're just going to have to get your own cookies.
Who knows, Angenette? You may have just done a segment that actually bridges the partisan divide in the United States of America. Who would have thought it would have come down to cookies? Thanks, Angenette Levy, for the Law and Crime Network.
Cookies and coffee, yeah.
Okay, Angenette, thank you so much. Okay, so let me go to you, Mike Corbanix, on this. Interesting what Angenette said. I have this legal question just pending in my head. I guess when the jury comes back with a verdict, if the verdict is guilty, then the judge still has to sign an order, or, usually most states have to sign an order or judgment of conviction. The judge has to hear this motion for a mistrial. I can't believe it is not being heard prior to the verdict. I thought the judge was probably waiting in my mind, because if there's a not guilty, then he doesn't have to throw this whole case out. But if there is a guilty, then he's got to do the real hard work. What do you think?
I tend to agree with you, Bob. In my experience, it's always been when there's a mistrial motion of this nature, a lot of times the judges will wait and see what the jury says rather than going ahead of what the jury may do or not. It may become a moot point. I don't know how the rule in Wisconsin is in the court rules, but up until the end of the trial and afterward, the judge can make a decision, at least in New Jersey, as to a new trial, as well as in the federal courts.
Okay, let's jump back now to Ahmaud Arbery, where Jason Sheffield is speaking to the court. Let's go to it. Well, we just wanted to give you a visual depiction of that while we go back to Paul Townsend on the same question to you, Paul. I just, my common sense, my experience, years of doing trial work, tell me that this actually would be the smart move by the judge, so long as their rules of procedure would allow him to handle the motion after the verdict. This way, if there is a not guilty verdict, it can be said that it was done by a jury of 12 who deliberated over all the evidence, that were independent, as opposed to a singular judge who's already come over a massive amount of criticism. And if the jury does come back with a conviction, then the judge is going to have to handle that motion for a mistrial. If that is procedurally proper to do in Wisconsin, do you think that's what the judge is doing?
Well, yes. Ultimately, I do think that that's what he's doing. And I think he's kind of being bailed out a little bit by the fact that the prosecution hasn't filed a response yet. You would think on an order of this magnitude while the jury's deliberating, it's not like they have witnesses to prepare for. If I was the judge, I would be telling the prosecutor, you've got to submit something immediately. I need to know what your response is. But at the end of the day, I think the judge probably, even if the prosecution did submit something, would wait, because that is, I think, the prudent thing to do. See if the jury is going to deal with this issue for him. I think in a case of this magnitude that is this charged across the country, this judge does not want to be the one to have to make this decision if he doesn't have to. So I think if it comes to the jury acquitting Kyle Rittenhouse, that's good news for him. If the jury convicts and then he has to be the arbiter, look, that's his job. He's the judge. It is what it is. But ultimately, I think if he can get out of having to make that decision and taking the heat for it, it's prudent for him to do so.
I have no question about it. And this is not a judge we know who's going to stand by for the prosecutor being lax at days ago getting his brief. He can rule on the motion and say, you waived your right by not filing your papers. So I think that's exactly tactically. Yep, right. That's exactly what he's doing. All right, we're going to take a quick break. Arbery's on a 5-minute recess. We'll be back with more Law and Crime when we come back. Please stay with us.
And ladies and gentlemen, the standard is likely to cause death or great bodily harm. Great bodily harm is defined as likely to cause serious bodily injury. A kick to the head is likely to cause a serious injury. Did my client suffer a debilitating injury as a result of that? No, but that's not the standard.
Defense attorney Mark Richards in closing arguments in the shooting by Kyle Rittenhouse of 2 people who were killed and 1 that was seriously injured. This is day 3 of verdict watch. This incident happened all the way back in August of 2020, has sparked a national and international debate with respect to this case. A lot of protests and a lot of people with some Both sides of the equation are very angry about the way this case has gone down, the trial, and the whole incident itself. Let's listen to a little bit more of the defense's closing statement as he talks about one of the victims who was killed, or the individuals who was killed, Joseph Rosenbaum, and about how Mr. Rosenbaum, was actually a threat that precipitated this incident. Let's take a listen.
Many people with AR-15s, not one person with an AR-15. That's the difference between this, the Ultimate Gas Station, fracas, and what happened down at Car Source 3. Kyle Rittenhouse was alone. He had been taken away from the herd, and Mr. Rosenbaum and Mr. Zeminski were going to get him. Movement. Mr. Rosenbaum and his bag. He's not dissuaded by the people. He's going right at them. He's not afraid of them. He's pushing in and going at them. He's not afraid of a gun. Yelling. Shoot me, N-word. Shoot me, N-word. Mr. Zeminski holding his gun down to his side, remembering this is a Black Lives Matter rally, and he's there to support their cause. Yeah, right.
Oh, shit. They shooting. Oh, shit. Oh, my God.
Think about that, ladies and gentlemen. The first shot happens, they barely begin to move. Between the first shot and Kyle's first shot, which is the second shot you hear, Kyle has turned around. Why is he turned around? Because that wall of people is there and he has nowhere else to run. The cars, the van, all of the people destroying property, the soda machine, he turns around and Mr. Rosenbaum keeps coming. Mr. Rosenbaum keeps coming, he lunges, gunshots.
Mike Corbanus, the thing about what the defense did in this closing in this particular area surprised me. He kind of blurted out some good stuff, but he didn't really bring life and develop it. I think what he was trying to say is that other people had AR-15s and weapons that were out, and there wasn't a problem. It wasn't until Joseph Rosenbaum got involved in the situation, and that's why this AR-15, to rebut the state's argument, the state was saying by bringing that weapon that Kyle Rittenhouse provoked the incident. And I have the jury charge in front of me right now. You may see it's kind of marked up there, a lot of highlighting and what have you, but on the provocation section, it's when a defendant engages in unlawful conduct, the type of which is likely to provoke others to attack. His argument is no one else is attacking, but they're attacking Kyle Rittenhouse. Wouldn't you develop that theme more? That this was because of all the circumstances, the gunshots, rocks being thrown at him, getting kicked in the head, skateboard. You got to add it all together when you're looking at what the defendant was facing. What do you think?
I don't necessarily think that's the greatest tack for the defense, because you really shouldn't have to add three different shootings together. And I think that's where they always come back to a major problem in the defense's cases, that this wasn't one person being shot. This was three different people. And I think that's a major problem. And also, I think the fact is, when I was listening in summation, I don't know how it helps the defense saying everybody else had guns. That's right. Everybody else did have guns. But this defendant was the only person who shot at two people who didn't have guns. And I think that's the major hurdle. And no matter how they try to put the window dressing on that defense, it still comes back to that.
Yeah, but Paul, I mean, I respect what Mike is saying, but the fact of the matter is, the state's sole argument, it's the state that's got the burden of proof. Their sole argument is that he brought that weapon, and that's the provocation. The fact that the rest of the group didn't go after any of those individuals proves the defense's point, in my mind, that they went after Rittenhouse, the puny, young, kid. And the fact of the matter is that the tapes don't speak for themselves. Rittenhouse was being attacked. I mean, there's no question about it. What do you think about the argument that Rosenbaum was an aggressor. Was he enough of an aggressor to justify self-defense in this case?
I think you have to divert, like you said, to the videos. And I think the videos do speak for themselves. I think there is a valid argument that can be made. And I think that Mr. Richards and Chair Fisi did an excellent job of sewing this together throughout the course of the trial. And I tend to agree. If I was defending Rittenhouse, I might have spent a little more time developing this in the summation. I know there were time limits and he had a lot that he wanted to say, but I agree that this was a fairly significant point on the provocation. A number of people were there with guns, and that didn't necessarily provoke anything in and of itself. It's not until, like, as you say, Kyle Rittenhouse is kind of separated from the herd. And, you know, we've seen the videos. We've all seen the videos at this point. He is unequivocally being chased, and a gunshot goes off before Kyle Rittenhouse's. He turns around. I mean, the scene is chaotic. It's horrifying. Trying to get into the 17-year-old's head is a Herculean task, I think, for the jury. But absolutely, I agree that the defense would have done a little bit better to really focus on that particular aspect, the provocation, and how that's just simply not here based on what the state was arguing.
All right, let's listen to a little bit more of the defense closing on the provocation piece.
Now, we've heard a lot about the Zeminskis in this case, and I just want to carve them out of this case right now because it's a red herring. It has nothing to do with any of this. There's been some focus on that because I think the defense was hoping they could work this into their self-defense claim and make an argument that that first shot by Joshua Zeminski somehow made the defendant fear for his life. Unfortunately, the defendant wasn't on board with that because in his testimony, he told you that that shot had nothing to do with his thought process. It didn't affect him in any way. He said he didn't think the shot came from Joseph Rosenbaum. He knew Joseph Rosenbaum was unarmed, and he admitted to me, you can't kill Joseph Rosenbaum for something Joshua Zeminski did. So let's just carve Joshua Zeminski out of this case. I'll deal with him on his arson trial in January, but until then, it doesn't factor into any of the decisions the defendant made. And in fact, as you see on the FBI video, the Zeminskis continue walking straight on down the sidewalk. They don't pursue the defendant. They don't threaten the defendant in any way. Now, the defense wants you to think Joseph Rosenbaum was there to attack the defendant. We'll never know what Joseph Rosenbaum was thinking because the defendant killed him. So we're just guessing. But let's assume for a minute, yeah, Joseph Rosenbaum is chasing after the defendant because he wants to do some physical harm to him. He's an unarmed man. This is a bar fight. This is a fist fight. This is a fight that maybe many of you have been involved in. Two people, hand to hand, we're throwing punches, we're pushing, we're shoving, we're whatever. But what you don't do is you don't bring a gun to a fist fight. What the defendant wants you to believe is that because he's the one who brought the gun, he gets to kill. So I want you to contrast this, two different scenarios. One scenario where there's two guys who are throwing punches at one another like a bar fight. I think we'd all agree you can't kill someone. You can't punch the guy, knock him to the ground, and then get on him and strangle the life out of him. That's murder. So what's the difference here? The only difference is the defendant brought a gun. He brought his AR-15. That's why he's got to come up with this cockamamie theory that Joseph Rosenbaum was not only going to take the gun, but take it and then turn it on the defendant. And the defendant actually told you that he thought Joseph Rosenbaum was going to take that gun and not only kill him, but kill other people, which is really ironic considering the defendant is the one who killed people in this case and the only one. But putting that aside, they have to convince you that Joseph Rosenbaum was going to take that gun and use it on the defendant because they know you can't claim self-defense against an unarmed man like this. You lose the right to self-defense when you're the one who brought the gun, when you're the one creating the danger, when you're the one provoking other people.
You know, Mike, we talk about this before. People are told, police officers are routinely trained that there's always one gun at every single encounter of theirs, and if that weapon is taken away from them, that they can use deadly force because they could be shot or somebody else can be shot. But I want to get into this provocation charge one more time. First of all, that was the prosecutor. I apologize. I said it was the defense lawyer. That was the prosecutor. This is so convoluted, this argument that he made to me and these examples that he was given. And even the jury charge, because the jury charge says, Mike and Paul, I just want to make sure that our audience is clear, that if you engage in unlawful conduct, the type likely to provoke another to attack, and who does provoke the attack, okay, cannot use self-defense. But then there's a caveat in the jury instructions. It says, however, if the attack which follows causes the person reasonably to believe that he is in imminent danger of death or great bodily harm, he may lawfully act in self-defense. Doesn't that consume the provocation charge? It's saying you can't provoke an incident and then claim self-defense unless you can claim self-defense. Mike, am I missing something?
No, it's very confusing, and it's so funny, Bob, that we always have this discussion. We're people who have been in courtrooms for many of years and have argued many different jury charges, yet we expect jurors who really most of the time are sitting on a jury for the first time to really learn about this kind of complicated law just after having a judge read it to them. Bob, I think we could debate this and try to figure it out for hours at a time with this provocation because it seems to constantly shift.
Yeah, okay, Mike, I appreciate that. And you're right. We often sit there and say, we're having a hard time figuring this out. How the heck is the jury figuring it out? All right, we're going to take a break, but on the other end, Jack Brinson from the Satilla Shores residence is going to be another witness called by the defense, presumably to talk about the crime issues in that community. Stay with us. We'll be right back. All right, since we've been on break, Jack Brinson of Satilla Shores got on the stand, talked about thefts, no cross-examination, and now we have Annabella Beasley from the Satilla Shores area who's now on the witness stand as well. Let's go to it.
The neighborhood was elderly. Now it's more younger families. Do you live with anybody in your house?
No.
Okay. Do you do anything to maintain your own security at your house?
I have recently, after all the happenings in the neighborhood. It was unnerving, and so I had to. She's single. She couldn't defend me. I got to protect myself. So it became necessary to have cameras put up.
Okay, and you have cameras at your front door, or what parts of your house?
I think I only have one at the front door.
Okay.
Yeah, and that was put on recently. So.
Okay. Did there come a time when you yourself became the victim of a property crime?
Yes, I did.
Could you tell us about that?
Well, I was in China, and my black Honda was sitting in my driveway, and my kids, I communicated with them every day, and they discovered that the car was broken into, the door was wide open, and they had been in, so they saw that it was all ransacked. And I asked my daughter if she reported it to the police, and she said no, because the week before, somebody's Jeep was broken into, and the police said, you should have locked your door. There's nothing we can do about it. And since my door was unlocked, she decided not to call the police.
Mm. Did you end up, when you came home from China, calling the police about it or anything?
No, it was way past, yeah.
Okay, so it was a crime that's unreported to the police.
That is correct.
Okay. Did you become aware of a situation where Subi's cameras, Miss Lawrence's cameras, went off one night in 2019?
She told me about it.
Okay.
Yes.
Did you, as a result of what she told you, did you do anything about that?
Not personally, no.
Didn't change security, didn't change
No. I have a security system in the house.
Right. Like an alarm system?
Right.
Okay. Now, you mentioned that Miss Lawrence has three boys.
Mm-hmm.
Are you aware of those boys ever going across the street to Mr. English's house to borrow some pieces of wood?
No.
Okay. Are you aware of them ever playing at Mr. English's house?
They played with Mr. English's son. And Mr. English's son would come across and play with them. And Mr. English, when they were using scrap wood to make a ramp, he said he would build them a ramp.
Okay. And do you know if that ever happened?
I don't know.
Okay.
I don't know.
Did there ever come a time when your grandchildren became too afraid to play outside?
Yes.
And do you know what happened?
Well, I think they were scared by what they saw. And when they called their grandmother one night, I wasn't there, and their mama was at a birthday dinner, and they saw somebody. Pardon me?
No, not you. You can sustain or overrule that objection.
Yeah, this is what she heard that the boys were reacting to.
Okay.
Let's just say.
Let me move past what they told you.
Okay.
Did there come a time where they stopped playing outside at night?
We wouldn't allow them to.
You didn't allow them. You say we. You're talking about you and Miss Lawrence.
Uh-huh.
Okay. And why wouldn't you allow them to play outside?
Because we didn't want them to encounter anything, you know.
I think this is all still based on hearsay from what she heard from either the board or somebody else. So the reaction or what they are allowing them to do because of that is still based on that hearsay.
Okay, let's focus on this.
Yeah.
It sounds like she made a decision. Let's figure out what her decision is and why.
Right, and that's what I was trying to do, Judge. Do not tell us what the boys told you, but did there come a time when they stopped playing outside?
That's correct.
And you said you didn't want them to play outside.
Correct.
And tell us why you and Miss Lawrence made the decision not to let them play outside.
Because of things that were happening in the neighborhood. Okay. We didn't want the boys out there. We didn't want them to confront or see anything that they shouldn't. You know, we didn't want them to be a victim of anything, so we let them stay inside.
The safety.
And even till today, they barely go out except now. Now that they're older, they will play, but as long as we are home, it's okay for them to be out there. But they do go across to Perez's house, and we're okay with that.
As long as they're being overseen.
They're right, exactly.
Okay. Was there a time, Miss Beasley, when you were interviewed by GBI agents?
Yes.
Okay, do you know when that was?
When the incident occurred.
The incident being the shooting of Mr.
That is
Arbery?
correct.
Okay, and you gave a statement to the GBI?
Yes.
Okay, all right. That's all I have. Thank you, ma'am.
Okay.
Anything from the state?
I just have a couple questions. Good afternoon, ma'am. How are you?
Good afternoon. Fine, thank you.
I'm Paul Camarillo. I'm part of the prosecution team.
Nice to meet you.
We may have talked on the phone, I
think
believe.
you did. You and I had a long conversation.
We did, right?
I do remember that.
Okay.
Now, yes.
Was it a good one?
Yes, it was a good one.
Okay.
I think I told you all that I was thinking.
You did.
Mm-hmm.
You did. You did. And not all of that is relevant evidence.
Okay,
All right?
gotcha.
So I just got a few questions for you, okay?
Mm-hmm.
You've been in the neighborhood a long time.
Right.
Okay. Is it fair to say that a vast majority of these crimes that occurred in the neighborhood were property crimes or car break-ins and that sort of thing?
Correct.
Okay. Other than the homicide of Mr. Arbery, violent crimes were few and far between or non-existent in the neighborhood. Is that correct?
That is correct.
Okay. Ma'am, that's all I have for you. Thank you.
Thank you.
May she be excused.
Yes, thank you, ma'am. You may step down.
Thank you, sir.
Is she under state subpoena?
No.
All right, and you are excused. Thank you.
Thank you.
All right, Mike, you like that cross-examination. I heard you say it. I would have jumped up as a defense lawyer and argued that he called it a homicide, and that is a fact in dispute in this case. But go ahead.
My point is, Bob, just from a trial attorney standpoint, it's so refreshing to see when a attorney, whether a defense or a prosecutor, does a cross-examination, makes the points they need to make, and get out. I think he was very effective because basically what he's saying is that there was only property damage going on there. Nobody was ever assaulted. Nobody's life was put at risk on any other date. And I thought that was very effective, and doing it in so few questions really was effective.
Yeah, Paul, let's show we have our true crime aficionados here, a lot of legal people that watch us. That is, I do agree, an artful way to go about cross-examining a witness. Just a couple of questions, and you're making your point to the jury, sometimes irrespective of what the witness answers. I mean, I like the style. What do you think?
I agree wholeheartedly with Mike. And I think also it shouldn't be understated that he also had a lot of personality and rapport with this witness, even despite the fact that it was incredibly short. He had the room laughing. He had them kind of enjoying the moment that he shared with her. He made the exact points he needed to make. He didn't overdo it. He didn't waste his time on extraneous questions. He got in, he got out. He left the jury with a very positive reaction from his cross. And I think that that is exactly what the prosecution needed out of that witness.
Right. Mike, again, though, these witnesses obviously are going to this quote unquote citizens arrest piece. Do you think the defense has at least done enough to show that these aren't just craven lunatics that are running out there looking to hunt somebody down for no reason, but rather that these issues were piling up and that's the reason why the community was on alert?
Well, I think that's what they're striving for. Whether they achieve it or not, we'll see what the jury says. But I do think it is a effective course that the defense is taking here in trying to put this together. As defense attorneys, you work with what you have. It does work to their favor. I think that there were prior incidents here. I just don't think those incidents will reach where it comes to anybody felt that they were at risk personally for physical danger. That's their biggest obstacle in the road they're traveling now.
Okay, well, I'm told we have another witness that's live in court, and since these are going fast and furious, let's get to it.
When did you move into Satilla Shores?
August 2015.
Okay. Was there a time before you moved in 2015 that where you lived in Satilla Shores?
Yes, sir. I moved there in 9th grade with my family, my mom, dad, and sister, into the house my mom lives in 1994.
Okay. Then at some point you moved out?
I did. I got married and moved out and got divorced and came back.
Okay. Okay. And so how would you describe your relationship with the Perez's?
Oh, very close. They are definitely good neighbors, good friends, like other parents to my boys. One time we actually had, the boys were playing baseball in the front yard and a ball went through the dining room window and Diego just happened to hear glass crashing and runs over and he had it repaired before he went to bed that night. And then Brooke's over with her vacuum cleaning up all the glass. So they look out for us.
So they're neighbors that help you.
Yes.
With all the things that three boys, right?
Yes, sir.
I want to go back to 2019. How old were your three boys at that point?
They were 8, 11, and 13.
Okay.
Ish.
Did they have any kind of relationship with Mr. English or his children?
Yes, Hoyt, Mr. Larry's son, and my middle are about the same age, and so they would play together. And Mr. Larry actually gave them some wood for a ramp, for a bicycle ramp.
Okay. Have you ever seen Mr. English's surveillance video of two boys on his property
I have.
On bikes?
Yes.
Okay. Do you know who those boys are?
Those are my children.
Oh boy. And what were they doing in that video, to your understanding?
They were going to get the plywood for the ramp Mr. Larry made them.
Okay. So they had permission, essentially, to get the wood?
Yes.
Okay. Did they ever go into Mr. English's house at night, to your knowledge?
No, sir.
I want to take you back to October 2019.
Okay.
Okay. Was there a time when your camera on your own home security system alerted you?
Yes, sir. It was late October, and it was late in the evening, so I want to say the boys and I were at a football game or the fair or something on a Friday night maybe that was, that had us out late, 10 o'clock-ish, I guess. And so I got an alert on my Blink cameras that, there was motion detected. So I look at it and I see two men with flashlights looking at the front of the house. And so, of course, I call Brooke and just say, there are guys at my house with flashlights. Can you please send Diego over to see what's going on?
Okay, and why would you ask Brooke to send her husband into a difficult situation?
Because Diego is...
There's no object speculation.
I asked her why. Yeah.
I feel very
safe with Diego. I know that he would look out for me and my boys, you know, at all cost.
Okay. And did you eventually come to understand who was on the camera that alerted you? Did you ever find out?
Yes, I did.
Okay.
Diego came over and figured it out and relayed it through Brooke.
Okay. Did you ever, as a result of that incident, talk to the police?
No, sir.
Okay. Did you ever post anything on the neighborhood Facebook page?
In general, yes. About that specifically, I don't recall.
Okay. When you say in general, what kinds of things were you posting on the neighborhood Facebook page?
Who do you use for a landscaper? The ice cream truck is in the neighborhood.
All right, let's take a quick break and we'll be right back. Subi Lawrence, a resident, is on the witness stand talking about the same thing about crime issues, being concerned about being outside, keeping their kids inside, about Larry English's home, people getting inside of the home, being an administrator on the Facebook page, all the same kind of testimony about crime issues in the area. Let's go back live to court.
So, of course, I was just a little more diligent about making sure that, you know, the car was locked and the doors were locked and windows that I hadn't checked and that sort of thing.
Did Brooke Perez or any other neighbor, or the Facebook page for that matter, ever inform you about how many times this black male was coming onto Larry English's property at night?
Not so much the Facebook group. It was probably more just text from Brooke saying, you know, get the boys inside.
Okay. And when she would text you that, would you make sure the boys were inside?
Yes, sir, absolutely.
Okay. How did that make you feel, the fact that there was someone coming over?
Violated. Upset that my kids weren't getting to grow up in the safe neighborhood I grew up in. Previously, we lived on some land, and we had a dirt driveway, and all they wanted was a neighborhood with roads so that they could ride their bikes. And so to have to say, come inside, stay inside, or Mom, I don't want to go outside, it was just disappointing.
Even though it wasn't violent crime, it still affected you and your boys?
Well, crimes of opportunity may not start as violent crimes. It's just someone's in the wrong place at the wrong time, and I didn't want my boys to be home alone and someone think because there's not a car there, there's no one home, and then they're in that situation without me.
Right. Okay. Thank you, Ms. Lawrence. Appreciate it.
Good afternoon, ma'am. How are you?
Hey, I'm well, thank you.
My name is Paul Camarillo, and I'm one of the prosecutors here.
Yes, sir.
We've never spoke before, right?
No, sir.
Okay. I may have left you a voicemail or two, but we've never actually connected, right?
No, and I'm sorry if I missed that.
Oh, it's okay.
Definitely would have called you back.
No, it's okay. Would you?
Yes. I'm very afraid.
All right. I'm not that scary.
Okay.
You and Mr. Rubin were talking about break-ins at Mr. English's house.
Mm-hmm.
Nobody there actually ever broke into anything. Is that correct? That you know of? It wasn't a secured house. Somebody walked through the door?
I don't know if there were even doors.
Right, there weren't. But
so Mr. Camarillo, that's testifying.
Just as your sons went in that garage, the open garage.
Yes, sir.
You're not aware of any sort of doors or windows or anything else that was on that property?
No, sir.
Okay. All right.
At the time that we're speaking of?
Yes, ma'am.
Okay, yes, sir.
Currently there might be?
I think so.
Okay. All right, so you're friends with the Perez's, close friends, right? Y'all have had dinner together?
Mm-hmm.
Okay, Paul, so what do we think of Subi Lawrence here? Yet another witness coming in but I thought very effectively talking about crimes of opportunity and almost choking up that she couldn't have her kids play outside because of their fears and concerns about what was going on in the community, especially with regard to, she said, this man, black male, that was on the property at Larry English's. Effective? Not effective.
Pretty powerful. I think she did a very good job of communicating what the defense wants, which is to kind of connect that bridge between these are property crimes, they're not violent crimes, but she was able to kind of put those together and say, well, property crimes can turn into violent crimes. And I think that was a connection that up till now had kind of been lacking. So good for the defense for pulling that together. Is it enough? We'll see. But I think that was the right move, and she's the right person and the right time to do that.
Yeah, Mike, clearly going to this quote unquote, the citizen's arrest piece, what were your thoughts of her testimony? And to Paul's point, her kind of tying in that crimes of opportunity can become worse and that it actually affected her having her kids play outside, getting choked up and teary-eyed about that?
Well, I think it was very effective for the defense. However, once again, does it meet the standard they have to overcome? My understanding of the citizen's arrest is that specific incident basically has to happen where you're the eyewitness. And I think that's going to be an interesting argument to hear from the prosecution and the defense in their summation as to that part of the civil arrest law.
Yeah, and definitely the part of that is going to be whether or not the state of mind of the defendants is going to be very, very important here. And it may even be important for the other two defendants that we really don't talk that much. Anyway, guys, thank you so much. You did a great job. I'm going to go. I'll be back Thursday between 12 and 3. Imran Ansari is next. Don't go anywhere.